Yep, I'm live. Hi everyone. Sorry for the slight delay. Can you guys hear me really well? If you guys can hear me really well, please let me know in the chat. Hi. If people can hear me really well, please let us know in the chat. That would be really, really helpful. Sorry for being a couple minutes late. We're going to give maybe another minute for people to join. Hi, thank you. Thank you for confirming. So I'm grateful that people have already been putting in questions. Please don't hesitate to put in more questions. This is kind of time to ask the questions that you would love to have answered, so we can try our best to get through today's conversation and today's kind of session, get you some insights. Okay, perfect. As a reminder to everybody who is joining today's conversation, remember that when you put a comment, it might be showed on the screen. It's not confidential. So if you have anything that's private that you really want to share with the world, make sure that you don't put it in the comment. The more general the questions, the better. Also remember that if I answer any questions, it's not really considered specific legal advice. It doesn't establish an attorney-client relationship, and it will never replace a true consultation, because I would have more information about you, more about your background, to give you a much more accurate picture. But let's go ahead and get started. I'm going to start first with a question here. Can an H-4 EAD with an LLC in the USA has done business in the past 2 years providing software development service apply for an agent-based O1? If yes, how does that help in building an EB1A? So in terms of somebody who has already done business in the past 2 years, apply for an agent-based O1, it can be one of the job offers that contributes towards an agent petition. As a reminder to everyone here who wants to seek an agent-based O1 petition, the purpose of an agent petition is to designate a third-party entity or a specific employer who is willing to serve as that multiple entities in a way, is to show that you have multiple employers or multiple engagements waiting for you in the United States. So it's going to be one of the many job offers would be your own company, and that's fine. And if in terms of the question of if yes, how does that help in building the EB1A? If you are approaching an O1 and you invest your time in putting together the materials for the evidence required for that O1, you're going to also be on that right pathing towards an EB1A as well. Remember, guys, the EB1A's criterions are pretty similar to an O1A's criterion. So if you're already going in that direction, it's more likely to either accelerate or put you in good footing towards an EB1A. I have another question here is, I am in the US and plan to travel to my home country for the first time visa stamping. Will those with approved H-1Bs have to pay $100K after the first time visa stamping in their home country upon entry? So I'm going to say it depends, but I'm going to tell you specifically what counts and what doesn't count. If you have an application, a valid application that was pending prior to or approved prior to September 21st of 2025 at 12:01 a.m. EDT, and you are subsequently now leaving the country in order to do visa stamping, then the $100K fee does not apply to you. Even better is that even after September 21st, if you file a change of status, an amendment, or an extension of status for your H-1B, and it's subsequently approved, you can actually travel thereafter and seek visa stamping thereafter. So you shouldn't have to pay the $100K fee. The only people who really need to pay this fee are individuals who file for an H-1B when they're outside of the country seeking consular notification. Clear example is that, let's say you were a student in the United States on an F1 bachelor's degree. You got your first job at Meta. Meta enrolled you in the lottery. You won that H-1B lottery in 2020. They changed your status back then into an H-1B. But then after a couple years at Meta, you decided, you know what, I want to get an MBA, but you got accepted to Oxford University. So you leave the United States, you study in the UK, you get your MBA, and now you got a job offer again at Meta to come back to the US. You can technically resuscitate your H-1B because you were counted against CAP before. You were counted against that lottery before. However, now it's a new H-1B application. There's been time that has passed. and you're seeking consular notification because you're not in the US, you're outside of the US, and you need to go to the consulate to stamp your visa in order to activate your H-1B for the first time upon entry. So it's those scenarios where the 100K fee really does count. The next question, also from Ricky M, is, will the 100K have to be paid for the case of a concurrent H-1B filing by a second employer after the 21st of September? It will only count again if you're seeking consular notification. There's actually a special checkbox on the I-129 that really tells you that you're going to be notifying the consulate, and that's what triggers that 100K fee requirement. But to make it even more clear, if you're in the United States on valid status and you're seeking concurrent H-1B employment and it's sought as an amendment or an extension of status, then there's no issue with the 100K fee. You wouldn't need to pay it. See here, my endeavors recovery. I built also case done. Am I eligible? So we have somebody who's asking, my endeavors recovery of aluminum from landfills. I've built a separator, process waste, but no citations yet. I have a master's and done a case study with the county on landfill mining. Am I eligible? So I think it depends, Daniel, because there's no explicit requirement on an EB2 and a W to be super cited. Right. And a lot of the times what I find from engineers who are developing some of these processes, especially in mining, is that you're in a very practical field. It is not normal for you to have all of these research accolades that traditional researchers have. What I will really emphasize to you, Daniel, that is actually more important is not even really the endeavor per se, but whether or not you are well positioned to advance it in the United States to the scale that is going to be of national importance. The government is going to want you to prove your roadmap. How is this going to have a national level of impact? Because if you're only working, let's say, for one specific landfill in one specific region, it's going to be harder for them to believe that this is going to be of benefit and national interest. And that's what you need to think about. Next question that I see here is, hi, I am a Canadian citizen on H-1B with an approved I-140. My project ended and I'm looking for new projects through a new employer. Can I switch to the TN visa without impacting my future green card? So you can switch to the TN. The only thing that I'm a little bit concerned about is whether or not the officer who's adjudicating your TN, especially if you decide to do a border filing, is going to consider that your I-140 is some level of intention to permanently immigrate. Remember that the H-1B is dual intent. The TN is not dual intent. Now, there is a lot of literature to say that your intention is not realized or it's not necessarily violated until you file the 485. But guys, times are changing. The question of intent and the question of what you want to do in your future is raised much more, even for Canadians who are seeking a border filing. In your scenario, I think I would be much more comfortable with a domestic filing to change status rather than exiting the country and risking those questions. Or better yet, if you need to buy more time to find a new role, you can always domestically change your status into, let's say, a B1, B2 or an F1, buy yourself more time, and then change back to the H-1B. All right, let's see here. The next question that I see is, does J1 applicants applying for H-1B academic entitled for the 100K? So Kaja, my answer to that question, if you are on a J1 and you are changing your status into an H-1B domestically in the United States and you're not seeking consular notification, you don't have to pay the 100K fee. For J1s, though, it's interesting. If you have a foreign residency requirement, 212B, basically you're going to exit the country, you need to exit the country, stay in your home country for 2 years before you can come back, or you need to seek a waiver. Changing status in the United States to the H-1B is impossible unless you're one of those foreign medical graduates that has that Conrad 30 waiver that allows them to do that. So that's something that you need to be much more considerate of if you have the foreign residency requirement. But a domestic change of status to an H-1B should not be required to pay the 100K fee. So I see here, when do you think the lawsuit will give an initial injunction or decision by? So I saw this question, and I actually saw this question from the same person the other day. There is no timeline for this. What I will tell people is that it is much harder compared to before. There was a time where these injunctions were flying left and right. But remember that in this year, the Supreme Court basically said, no, you need a class action lawsuit. There needs to be a process before you can issue a federal injunction. So I can see it taking much longer than anticipated, maybe several weeks, maybe even a couple months before there's like a rendered injunction that is issued. But I cannot say for a fact when that is. I will also let everybody here know that I am not a litigation attorney. I am not somebody who does a lot of administrative filings, but I'll tell you from experience that I know things have changed a lot this year, and I do anticipate that these injunctions or decisions will take longer. Sorry, guys, I accidentally hit the back button trying to scroll between things. Just to let everybody know on Instagram, if you guys are asking questions there, it is much harder for me to see them because I think I saw a few scroll by. So I have one here. I have a question. Someone's H-1B is expired and they are currently in a receipt notice. Can they transfer to a new employer on the H-1B receipt? I heard something about a bridge petition, any inputs, right? So if you are on your 60-day grace period, so I think that's what you mean, and you filed to change employers and that is pending, but you found a new employer, you could theoretically bridge it again by filing another H-1B change of employer application. The problem is that it depends on whether or not you're still in that grace period. Or not. Because if you're still in the 60-day grace period, then that's okay because you can always abandon that other change of employer application that's pending, no longer moving forward with. But if you're bridging it on top of it because you're out of the 60-day grace period and what's allowing you to stay is that pending H-1B, then I would recommend paying for premium processing to accelerate that first H-1B filing that you have, get it approved, and then file that second one. All right. So let's see here. I'm trying to make sure that I get to everybody's questions. There's a lot of them. Let's see here. I am a Canadian citizen with H-1B. Can I switch to TN? Oh, I already answered this one. Are nonprofit cap exempt organizations exempt from the 100K fee? Noting that I'm now working in the US on my OPT. There is no specific exemptions for nonprofits or cap exempt. The exemptions only apply if you are filing to change status into an H-1B, including these cap exempt ones and the nonprofit ones, amending or extending your status on an H-1B. So what does that mean is that the only people who are impacted by this 100K fee is if they are outside of the country seeking consular notification and they're not in the US doing either a change of status, so you're going from like your F1 to your H-1B, or an amendment, you're already on an H-1B and you're trying to declare a material change, or an extension of status, which is that you're renewing or even changing employers. Next question is, I am a J1 researcher. Could you please clarify whether there are potential downsides or implications of a green card application being rejected on my future J1 visa applications, right? So the downsides is that by the time you seek an I-140, at that stage, the government is basically notified that you as a person are involved with the case. And in certain perm processes, you would also be declared at the Department of Labor stage, but I wouldn't be as worried about it. If you have a pending, whether it's approved or rejected green card application, I mentioned this earlier, remember that J1s, F1s, TNs, those are single intent visas. You could always find an officer who has access to these records who will question you and say, do you truly intend to actually return to your home country at the end of your stay, or are you trying to permanently immigrate to the US because you filed this application? Under more liberal administrations, the perspective is that you haven't violated your intention or you haven't shown your intention until you file the 485, the adjustment of status. But I would be very careful in this day and age. I think that could be a potential downside. However, if in the long run, you are wanting to be a permanent resident, then I usually encourage people to focus on pathways that would give them that objective. And maybe you need to think about an alternative. How do you exit the J1 researcher, go into an H-1B, or go into an O-1 that has better protections against some of those findings? And then I have another question. Will my sponsor pay the 100K fee if a new H-1B is filed while I'm in Canada? As a Canadian citizen, I'm exempt from visa stamp. I don't think I need consular processing. It's still considered a consular notification because you have to enter through pre-clearance. You still need to have an activation. Your sponsor will still need to pay the 100K fee. They even mentioned it in the announcement. It's like port of entry filings and pre-clearance filings as well. At the end of the day, like you still have to go through a process, even as a Canadian, even if you don't need a visa stamp, which I very much understand. It's still a consular notification application. Let's see here. Why did they change my O1 to H-1B when I submitted it? Is it because my information is not enough? I'm not sure. That's a very interesting question. I don't know why they would change something, but I think maybe somebody changed to your H-1B, like maybe a company preferred using an H-1B. H-1Bs are easier to file, to be honest with you, than an O1. Does the company have to pay the 100K when the applicant goes back to their home country for first-time H-1B stamping? So if you got your change of status approved in the US, so I'll give an example. I'm on F1 OPT. I won the lottery next year in 2026. I filed to change my status to the H-1B. It's been approved. Now it's already October 1st, October 15th. I want to go home to my home country, get a stamp because I would like the ability to travel. The government basically said on its published guidance, the updated one on the H-1B page, that subsequent to that petition approval, travel is allowed. So you wouldn't be charged that 100K. Quite explicitly, the only people that need to prove the 100K are individuals who file for consular notification. I know that this is a really weird concept, but look at the I-129 form. And I wish I could pull it up for all of you to see. But on the I-129 form, there's literally like a section where they ask the attorney, is this a change of status? Is this an extension of status for someone who's already in this status? Is this an amendment to somebody's status? Or do you need to notify the consulate in order to finish off the processing because you're outside of the country? If they check off that box where they're notifying the consulate, that's when the 100K fee appears. NIW I-140 has been pending for the last 13 months. So what would you suggest at this time, given filing a premium processing might lead to an RFE, as officers might not be reading the petition carefully? I still think that anecdotally premium processing has had much more pushback, but even then, like how much farther can anecdotes go? There's no like published data out there. There's not really a collation of data. The government doesn't say anything about RFE rates based on premium processing or not. But if it's been pending for at least 13 months and you really want an answer, then I don't see why you wouldn't upgrade to premium processing. Let's see here. What is the best strategy to transfer from a pending B2 visa to a cap H-1B to avoid the 100K fee? And is an F1 visa a safe backup plan? Well, there's no like strategy, because in the sense, like the government is saying that a change of status to an H-1B is exempted from the 100K fee, right? So that's what it says. It says if you're filing to change status from a valid status to the H-1B, there is no fee. However, you're on a pending B2. Pending B2 is not really a valid status yet until it's been approved. So it's possible that when you file to change your status from this pending B2 to a cap exempt H-1B, the RFE that's going to come back is that we need to wait for the B2 filing to be adjudicated before we can even adjudicate the H-1B. And if that bridge B2 application is ultimately denied, that's when the 100K fee is definitely going to come up, because you're no longer in a valid status. You can't change into something from nothing. Can USAS decline your petition and force you to do consular processing? Technically, yes, but it does depend on what triggers it. If you abandon your application by traveling while it's pending in a change of status, then yeah, they can decline to adjudicate the change of status, but sometimes they will either issue an RFE or tell you that they've approved it for consular notification instead, or can approve it for consular notification. But I will tell every single person, if you're filing a change of status or an amendment, or an extension of status, the best thing that you can do is stay in the United States until it's been approved before leaving. I understand that historically, if you file an extension or an amendment, you can travel while things are pending. However, at this stage, I would not recommend it. And even the government themselves in this updated guidance cautions against traveling while these are pending. Do you have any policies showing that the 100K fee will not be needed for J1 to H1 exchanges in the US? It's literally on the government website. They basically said it is the H-1B website. If you go on USCIS, literally says if you're in a valid status, right? You're on any valid status in the United States, right? J1, O1, B1, B2, changing into the H-1B, then you're exempt from the 100K fee. And I think when I'm talking about this and I'm being very firm about this, remember what the proclamation is titled. It's a restriction on entry, right? A restriction on people entering the United States by having them pay this 100K fee. That's the reason why they're limiting the people that need to get this 100K fee to individuals who are outside of the country. So there's no specific, like, you're never going to see the words J1 to H1, no big deal, no problem, no 100K fee. It's literally the interpretation. It's literally they're saying if you're changing into the H-1B from a valid status, it's exempted. But Bersan, in this case, if you need a stronger explanation, you have to basically look at the forms or talk to an attorney. The forms will declare the fact that you're changing into the status. You need to be in the US on a valid status, changing into the H-1B for it not to qualify. Let's see here. I am a postdoctoral on the J1 visa, and I've worked for the DOE funded projects on municipal waste characterization and valorization. If I start my NIW process, will we be able to renew my J1? Those are distinct processes. I think you should be able to renew your J1. My only concern is that sometimes government-funded J1s have the 212E requirement, the foreign residence requirement. So, Rahman, I would recommend that you go to whoever is responsible for your program and double check that you don't have this foreign residency requirement. Because even if you get approved for an EB2 and IW, you can't adjust until you fulfill that foreign residency or get a waiver. I asked this question last evening, but I couldn't understand your reply properly, so I am repeating. Should I file an O1 before my 485, my cap exempt H-1B? Yes, you should file your O1 before your 485. That's a clear answer. I think it's because my perspective is very much that an O1 is not the truest of dual intent visas. At the end of the day, if you ask the government what is actually a dual intent visa that allows you to permanently immigrate or allows you to have the intention, it's the H-1B and the L1. And how do I prove this? An O1 can be denied under 214B when you go abroad. An H-1B and an L1 can't. Second to that is that if you have a pending adjustment of status like a 485, the H-1B and the L1 allow you to travel even before a travel permit is provided without abandoning your 485. So clearly the H-1B and the L1 are the only ones that truly in the law have true dual intent provisions. Can you suggest a good attorney in Atlanta for employment immigration law? I want to remind everybody that Manifest is a national firm. We have lawyers all over the country, and also that employment or immigration law is federal law. Employment immigration is, right? So you don't necessarily need to be barred in Atlanta in Georgia in order to advise clients in Georgia regarding immigration because it's a federal practice. And then I have, do recommendations play any part in the EB2NIW? I have been working in the autonomous vehicle sector and have a practical project track record with industry and the US Army with less focus on citations. So recommendation letters do play a very powerful role for an EB2 NIW. I really do consider them part of the backbone of what makes a good NIW. Why? Because these are the only experts that can really affirm outside of tangible achievements how you are positioned to advance something and also be able to express the importance of your endeavor. So recommendations do play a part, especially really strong ones. Don't ask your best friends. You need to be asking truly experts in your field to not only affirm the reasonableness or the merits behind your endeavor, but you need to also have them express what makes you very much the player or the best person to be pushing this particular endeavor. So I see this question a lot, like when it comes to O1s and EB1As, like what's the minimum publication reviews that you suggest to satisfy a criteria? And it's not even just about this particular category. It's about all of the categories. Every single person wants a benchmark or a yardstick. But what I will tell every single person is that there's no such thing as a benchmark or a yardstick. It depends on the quality of the evidence. So let's take, for example, the press category. there's always a question of, is one publication interviewing me enough, or do I need 3 or 4 or 5? Well, one can be enough if you were interviewed by the New York Times, if you were interviewed by CNN, right? There's a lot of value to that, and it's weight in gold compared to 50 different interviews from smaller publications, right? So that's what I tell people, is that I wouldn't say the lower the quality, but the lower the impact of that particular piece of evidence, the more that you need of it, versus like the one really big achievement that can really fulfill it. So there's a big difference between peer reviewing for Nature, right, as a biologist, versus peer reviewing for an international journal that nobody's heard of. My company is a nonprofit organization and it is not associated with any research institution. It has tax exempt status. They're trying to file an H-1B. Do I qualify for non-exempt cap exempt? So what you mean is cap exempt. There's not every organization qualifies for a cap exempt H-1B. You're either a college or a university. B, you are a nonprofit research organization, meaning that one of your primary responsibilities, not primary goals as an organization, is to conduct basic or applied research. Or 3, you have a affiliation agreement with a university or a college. There's also government research organizations that also qualify for cap exempt status, but those are the general ones that do. So based on what you are telling me, it doesn't really seem like your organization would be qualified for a cap exempt application unless you can prove that there's basic or applied research as one of its primary missions or objectives as an organization. I am currently on OPT, which will expire in June of 2026. I want to file for the NIW in hoping that I will have an answer in time before I run out of status. What is my best course of action? So, Bethany, I think you actually have a bigger problem here, right? Which is that you are saying that you are only allowed to stay here until June of 2026. The EB-2NIW, even if it was approved today, assuming that, it was pending maybe even earlier this year, is not going to give you any benefit to stay beyond June of 2026, because there's something known as the visa bulletin. Just because you've been approved for the EB-2NIW doesn't mean you can stay. You actually need to get a pending 485 adjustment of status in order to request for work authorization. But right now, there's a backlog even for people who aren't born in India or born in China. I think I'm going to pull up the visa bulletin right now just so people are aware of this, because I think there's a big misunderstanding in the market. I think a lot of people think that once I have this I-140 approved, I can stay. That's not the case. The I-140 just proves you're eligible for the green card. So for November of 2025, the government is basically saying, if you want to file that adjustment of status to stay in the United States, looking at the dates of filing, you needed to have filed that EB-2NIW if you're not born in China or India prior to the 15th of July, 2024. So Bethany, I think you need to figure out an intermediary status. You need to either extend your F1 in some form or way by going back to school, or changing your status to an O1, or maybe you win the H-1B lottery. I am on L1A at present. Can my company raise my H-1B under change of status when I'm already on a valid L1A? Is the 100K fee applicable in the scenario? So if you do have access to an H-1B, whether it's that you previously held one or you maybe win it in the upcoming lottery, then you should be able to change status from an L1A to an H-1B, even if your L1A is still valid. A lot of people who are on L1s actually change to H-1Bs because L1s, even though there's a benefit to them, they're either valid for a maximum of 5 years or valid for a maximum of 7 years cumulatively. And you cannot break those limits in the same way as the H-1B does just because you have an approved I-140. So people do regularly swap, especially when you're born in India or China who need more time, from the L1 to the H-1B. The 100K fee would not be applicable if you're filing the H-1B as a change of status in the United States and you're in the US. Is there any clarity if any professions will be provided waivers from the 100K fee? Will those with an approved NIW I-140 be eligible for a waiver from the 100K fee? So this is actually very tricky. And the reason why is because there has been no clarity. The government basically says on an extraordinary and rare circumstance, we may give exemptions. They did give an email address to apply for those exemptions, but they really are saying you need to prove that, it's not going to jeopardize American workers, that it's going to be an extraordinary circumstance that requires it for the best of national interest for the US government. So this is what I would say is that if you have an approved NIW and your H-1B rule contributes to that NIW, I would like to think that you have an argument, but it's one that your attorney would need to be willing to make, and it's not guaranteed by any means. But the government has not set aside any specific waivers other than you can ask. Is it true that USCIS can reject your change of status but approve it only for consul processing? Yes, they can if they wanted to, but there usually is a specific reason for it. I am on OPT on the F1 visa category and want to visit my home country in December 25 for 2 weeks. Will I be subject to the 100K fee because of the international visit before the 2026 lottery? No. You should not be subjected to the 100K fee in this circumstance. Okay, I see a lot of repeated questions. Right. Is it possible to get an O1 approved for tech entrepreneur, startup founder in case where I have no research or publications? And is it possible to get an EB1A approved as well? Yeah, because I don't necessarily think that tech entrepreneurs or startups need to have research or publications, right? I think there's a big misunderstanding that the O1 is this Einstein visa only for scientists. Does it really heavily reward scientists? Yes, because I think when it was established in the 80s and 90s, there wasn't really these common conceptions of like practical applications of engineering, practical applications of like science, other than I'm a lab coat person in a research laboratory conducting research. But here we are in 2025 using the same rules, but there are other categories out there that aren't based on research and publications. There's press about you, there's original contributions of major significance, there's high remuneration. So Nisharg, if you're really curious about whether or not you can get them approved, I think it depends on the kind of accolades that you have as a tech entrepreneur. Maybe you need to be judging hackathons or pitch competitions if you're in that space. Here's a good one. I'm on my 4th year of H-1B and was recently laid off. If I return to my home country and a new employer files my H-1B transfer, does the 100K new fee requirement still apply? Yes, because you're outside of the country. They're going to have to check the box to notify your consulate in order to return to the US. There is one gray area, though, which is if you still have a valid H-1B stamp, because that's what CPP says is an exemption to the rule. But I will tell you that based on the language that is out there, where it says if you're seeking consular notification, then you would be subject. I would rather you try to find your way to stay here by filing a B1, B2, maybe changing into that, or changing into some sort of intermediary status. Maybe you're married to somebody who is on their own H-1B and you seek an H-4 instead. So, with H-1B, traveled to the US on the 10th of August of 2025, returned on the 22nd of September 2025, visa valid until September 2027. I can only travel to the US after March 26th with a new employer with transfer option, I believe. My employer need to pay. This is actually a very difficult question because I'm not really sure, because if you're working right now, why can you only travel to the US after March 2026? Do you mean like you return to your home country on the 22nd of 2025? If that's the case, then if you're filing a new employer, that's technically a consular notification. Let me see here. If I have filed my 485 based on an approved EB1A I-140 self-petition and I am outside the 60-day grace period for the H-1B following termination, do I still have legal status? You're on pending status. You're allowed to stay. You have authorized stay. You can stay here while the I-485 is pending. But that H-1B has been kind of essentially let go. You can resuscitate it in the future, but what's allowing you to stay here is actually the 485. In that situation, can I file for another H-1B or an O1? If you're outside of the 60-day grace period, then no, you can't, because now that underlying non-immigrant status, like your I-94, is already out of status. You can't change your status. You're here on that pendency of the 485, so stick to it. Do you envisage any further changes like professions being exempted or the national interest exemption being expanded? The government only provided an email address. I'm going to tell you that my perspective is that if there is a qualifying candidate or a qualifying company, it doesn't hurt for them to try to get the exemption. But I don't necessarily think the government's going to be starting to make broad statements on who is exempted or not. I know Bloomberg several weeks ago said that there's going to be exemptions built in for physicians, but I haven't seen them yet. And I don't think we've ever gotten an update on it. There have been several X accounts spam tagging USDOL and USCIS on any immigration news regarding H-1B. Do you think USCIS feels pressured and could make rules based on that? Maybe. I think there's a reason why they updated the guidances on their website is because they're probably getting a ton of inquiries, whether it's from their press room or from the back end or from Twitter, etc., being like, I need clarification. Like, it's really hard for me to adjudicate or to do things unless I know what qualifies or doesn't qualify. I bet you there's also a lot of internal questions from officers, from outside agencies that deal with immigration like CBP. So I digress. I think there is a lot of pressure, and I think USCIS could keep adjusting their guidances to try to make this as easy as possible for themselves, is one way that I would think about it. All right. I have another question here is, I'm based in the UK and I have a doctorate in engineering in material science and engineering. I have a number of grants and funded projects based on my research, not many papers, any chances for NIW. I think what you need to consider is what is it that you're going to do in the US? I understand that you have a lot of accolades in your past and that you're based in the UK, but what does that mean for the US, right? What are you going to be doing in the US, and can you prove that these things are going to happen? Every single client that I've ever talked to for an NIW, I always remind them that USCIS is trying to determine, they look at this magical crystal ball in front of them, which is your application. Do I believe that 51% of the time when I look into the future, that this endeavor that's being declared by this person is actually going to happen? 51% of the time. So it's not just about your accolades. It's not just about, the fact that you're somebody who is well credentialed. It's about whether or not there is actually a real endeavor that's going to be driven forward for a national level of interest or national level of impact. Another follow-up question. If I get an EAD based on a pending 485 and I'm outside the 60-day grace period of H-1B, then what's my situation with regards to the possibility of another H-1B filing or own filing? Well, you can't, because an EAD is not a status. An EAD just gives you the authorization to work based on that authorized stay that was granted on your 485. You can get a consular notification for an H-1B or an O-1 approved, but that doesn't help you, because if you leave the country and you try to come back on a different status, trust me, it's going to be very, very bad for your 485. Because the status that you were in is like lost, right? Artist 01B was sent August 29th tracking number. U.S. Post Office confirms immigration received on September 2nd, but still after 8 weeks, no receipt. I-797 money order is not cashed yet. I will say that it is kind of out of the ordinary to wait that long, but at the end of the day, there's just been so many delays with like the regular receipt notices. I would definitely double check your application to make sure that everything was, dotted with the I's and the T's, right? So it's very possible if it hasn't been cashed yet, you may want to consider refiling, see if you can cancel that money order, but I don't think we can. Can someone who has an I-140 approved on a valid H-1B leave the country for, say, 3 years and wants to return back by a new employer / petition, and it would be COS, would the 100K rule apply? How would it be a change of status if you're not in the United States, I guess? A change of status means that you're in the US in a valid status and you're changing into the H-1B. Yeah, so that would not be a change of status. A change of status is that you're here in one status changing into another status. So that then the 100K fee would apply to you, because if you're outside of the country. I'm going to see if I can see some of the questions that were raised on Instagram. So give me 1 second, guys. Hi, I'm in the USA. My H-1B transfer was filed and received during the grace period and was approved after the grace period was over. Will I get an I-79A or 797B in this scenario? You should get an I-797A if it was properly filed. This is a follow-up question to the person who said that, hey, I didn't get any answers. Petitioner tried to call immigration, but they refused to give answers. Yeah, because they're not required. There could be a way for you to ask for lockbox support, but I think the government shut that down recently. So I would just refile if you've been waiting that long for a receipt notice. I'm in my grace period nearing the end of it. Is B2 change of status still a good path to buy more time? My I-140 is approved. Ooh, that's a tough one because it's the I-140 stuff that scares me, guys. I'm a little bit more of a conservative attorney, and part of it is to do with the fact that I always want you guys to succeed rather than not. Again, there's a perspective in the law that your intention is not realized until a 485 has been filed, right? That adjustment of status. But I always am cautious because if you file for a B2, like to say that you're a tourist, but you have an I-140 application approved, that doesn't line up. I haven't seen denials based on that though. I just want to make sure that you're aware that the intention doesn't really like gel well in my mind. That was answered. Hi, I am in the process of a change of employer and planning to travel to India in January. Is it safe to travel? Will I require fresh stamping? Do I need to pay $100K? If you're in the process of a change of employer and it was filed after September 21st, do not travel. You need to wait until it's been approved and then travel there afterwards. So somebody followed up saying consular processing. Then yeah, if you're doing consular processing for the H-1B, then as in like it's a consular notification H-1B, then you will need to pay the $100K fee. I am a CAP exempt physician. The job had to fulfill the requirement already outlined in the exclusion criteria for a current pilot. Would I have to, again, have an email to receive this requirement? There was no exclusion criteria for the current proclamation. I'm not really sure what you mean. Like, if you look at the proclamation, they said that the Secretary of Homeland Security can make designations, but they never announced any designation for those exemptions. So find me the literature or find me the regulation, because I'm more than happy to be proven wrong, and I would love to see it because this will be great news for everyone. Find me the literature that says that physicians are exempted, period, through CAP exempt filing. Can I start working on a TN visa receipt if I file for a change of status from H-1B to TN within the US? I've never worked on a TN. No. Portability doesn't apply here. So portability, for anybody who doesn't know, is that if you're on an H-1B and you file a transfer to a new employer and you're in the United States, you don't need to wait until that new H-1B is approved to start working for the new employer. But that doesn't work for TNs. For TNs, when you file to change into a TN, you cannot start working based on that TN for that new employer without that TN being approved. Is it normal to wait 8 weeks? Do I need to do a pro-nunc tank? I don't know if you need to do a nunc-pro-tunc, Nancy, because I don't know what your statuses were, but I think this is a pretty serious issue if you feel like you're out of status. I would recommend that you speak with an attorney immediately. I wouldn't even talk, like, I don't know what your petitioner is. I don't know if they hired an attorney to do it, but you need to talk to an attorney then, because 8 weeks is pretty long, especially without the checks being cashed. Because I can see the checks being cashed, but then like no receipt notice being issued because mailing issues. If a non-US company with no office in the US wishes to apply for a concurrent H-1B, then what is the procedure? Does it require an agent? There's no such thing as an agent H-1B filing, just to make that clear. So this is kind of like a moot question. I am not a big fan of H-1Bs that don't really have any offices, but it's not an explicit requirement. You can work remotely on an H-1B. By the way, guys, if I keep looking at 2 different places, it's because we have one for Instagram and one for YouTube. I'm trying to like make sure that I keep attention to both. When on a concurrent H-1B, what is the minimum hours of work for a second employer? It could be like 5 hours for all I care. That's how it works for a lot of different places, 5 hours. I think max that I've ever done is like 20 hours because it's hard for the government to believe that you're working 2 40-hour-a-week jobs. How should concurrent H-1B be specified in the petition? The hours vary per week. It should be whatever your minimum number of hours is going to be. But I don't think the government's going to like you getting approved for a 1 hour per week thing. If I have an approved I-140, would a B1/2 automatically be refused due to immigrant intent? Not necessarily. I've seen people get approved for it. I think what I was trying to raise is that I'm very considerate of the fact that it is up to an interpretation, right? The question of whether or not an I-140 alone shows intent is an arguable question. Under the previous administration, definitely not an issue. Under the current administration, there's not enough data to say whether or not it's an issue. It's just something that I'm very considerate of. Not a physician per se, but the job is a national interest. No Americans want to work there, and fee is a burden. Job is something. These are the same. They're not. It's not an exclusion. They're saying that these can qualify for an exclusion, but the Secretary of the Secretary of Homeland Security needs to certify that. So you need to submit that email and that argument. Wait for that email back that approves it, and then you can say that you're exempted. But there was no specific exemption. They just said that if the Secretary of Homeland Security agrees that there's no impact and that it's of national interest and all these kinds of stuff, right? That doesn't mean it's a blanket exclusion just because you yourself are saying it's of national interest, right? I can understand that it's in an underserved area and there's a lot of evidence for it, but you need to argue for it and you need to get that approval first. I think, yeah, I heard about the non-protonc and I asked you about it because I have no idea, but all I can tell is that my visa hasn't expired yet. Nancy, you need to talk to an attorney. This is very, very specific to your circumstances. Like, this is very hard to answer in this context because there's too many because every case is different and everybody's statuses are different. Like, it's not enough for me to be able to say based on this conversation alone, whether or not you need a non-protonc. Does a change of status to the F1 affect the ability to use an approved I-140 for a future cap-exempt H-1B filing? No, but I will say that it's kind of interesting to change back to a non-immigrant single intent visa post an I-140 being approved, but I've seen it be approved. Hi, can I apply for a work H-1 while I'm on a tourist visa in the US? Technically, yes, but if you even have access to an H-1B. Most people for H-1Bs, you need to win a lottery, and that lottery occurs every single year in March. And even then, you can't start working until October 1st of that year. The only people who can work H-1Bs like year-round or apply for it year-round are cap-exempt H-1Bs. Can someone simultaneously apply for STEM OPT and H-1B? Yeah, STEM OPT is a work benefit. Apply for it. But be considerate though, because the H-1Bs, remember, if you're on an F1 and you're changing into the H-1B, like domestically, that's what exempts you from the 100K. And the moment that you shift into the H-1B, your STEM OPT becomes moot because you're no longer part of the F1 program. Okay, so now checking on Instagram for some of these other questions that came up. Academic question. H-1Bs are reserved for tenure track positions. Are universities back to hiring if you live in the US as per your last post? H-1Bs are not necessarily reserved for tenure track positions. I've definitely worked with universities before that don't require you to be on tenure track to be sponsored for the H-1B cap exempt. There's no law that says that it has to be a tenure track position. All right, more questions here. Will a dentist on H4EAD need the 100K to switch to H1B? There's no, so just to say it out loud even more clearly, because I know I just mumbled that, will a dentist on H4EAD need a $100,000 fee in order to switch to H1B? The answer is, if you're filing it as a change of status in the US, there is no 100K fee, but if you're seeking consular notification abroad, then there is that 100K fee. Okay. Any limitation for TNs to switch back to H-1B to avoid the 100K? Was back to Canada for a couple of years after 1 year of usage on the H-1B. If you're in the United States on a TN and you're filing to change status to the H-1B, then you don't have to pay the 100K fee. So do that. Don't do it as if you're in Canada and you're seeking consular notification and you're just going to show up at the border and enter. That's not what the government's looking for those. I see a lot of people are asking like political questions. As an attorney, my perspective is that I'm here to answer factual questions, right? I'm not really going to be here to give a very specific opinion. What I will say is that I'm more than happy to answer as many legal questions as I can in the context of this conversation. Could you explain what is consular notification abroad with respect to the H-1B? So I think there's a lot of confusion here because consular notification is a specific selection on the I-129 form. So I know some of you are watching me through through Instagram, so you won't be able to see this. So I'm just going to make the judgment call right now and show you guys the I-129 form. So if you guys are interested in me actually showing you where on the form this box is and where the triggering is, please go on YouTube and go on our Manifest Law YouTube and watch it from there, because I'm just going to pull it up and I'm going to show it on the screen at this stage. Give me one moment, guys, because I think this is very helpful and very important. So if you guys want to share it with your friends right now, or this link so that I can show it to you in real time, that's probably like a great idea. Okay, let's see here. Let me see if I can share my screen. I got it. Okay, add to the stage. All right, do you guys see the forms? Can somebody say in the comments if you guys see the forms on the screen, because I don't want to do this unless people can actually see it. Please comment on YouTube if you can see it. Sorry, Instagram, you're not going to see it. Okay, cool. Right, so hopefully this is helpful. I'm going to zoom in. All right. So on page 2 of an I-129, and the I-129 is the form that anybody files when they do an H-1B. The first kind of set of questions is like, what's the basis of the application? Is it that this is a new employment? Is this continuation of a approved employment without the change? Like, is it a change in previously improved employment? All this kind of stuff, right? Where the 100K fee kind of comes up is actually on question 4, the requested action. And you'll see that there's A, B, C, D, E, and F. If you mark A, notify the office in part 4 so each beneficiary can obtain their visa or be admitted. This is what we mean by consular notification. Checking off that box, checking off this particular box, because everything else is exempted right now. So for example, B, change the status and extend the stay of each beneficiary because the beneficiary is now in the United States in another status. So that was what they were saying, is that you're exempted from the 100K fee if you're changing your status from a valid status to another valid status in the US. They're literally saying right here, are now in the United States in another status, right? They're also saying you're exempted if you're extending the stay of each beneficiary because the beneficiary now holds this status. What they mean is you hold the status in the United States. That's what an extension is. You can't file an extension for someone who's outside of the US because you're not extending the stay. You're not here. You're not on a stay yet. And then you have amend the stay of each beneficiary because the beneficiary now holds this status and are not seeking additional time from the current authorized period of stay. This is the amendment, which is like if you change job locations on your H-1B and you're just telling the government that I'm changing the location, then D is where this question really lies, right? So I want to repeat it one more time. I'm going to like zoom in like as much as I can for you guys to see it. It's this box, guys, that when it gets checked off, that's consular notification. You're outside of the country. Was that helpful? Does anybody need more clarification? Like, this is really the box that you need to be watching out for. Okay, let me know if that was helpful. Okay. All right, guys. So we're getting closer towards the end of this Q&A. Does anybody have any other questions? I'll try my best. I'm trying to keep up with all the questions that are coming in, and I'm trying to bucket them. Mm-hmm. Hi, I got my I-140 and will apply for adjustments soon, but my H-1B visa will expire on April 2026. Should I extend my H-1B visa first or just apply for adjustment and later apply for extending H-1B? It doesn't hurt for you to apply for your H-1B visa first, but you can actually apply for your adjustment and then extend your H-1B. You're allowed to extend your underlying status. It's where you change statuses that things get weird while you have a pending 45. Yes. To this question, you think entering on F1 and then adjusting to H-1B is a better strategy to avoid the 100K fee? Yes. But be careful. Intention still remains a thing. Although going from a non-immigrant visa to a non-immigrant visa is usually okay. Just, you need to be honest when you're entering the country. If you're telling the government that you're coming to the US to study, then you should really be coming to the US to study. All right. So I think we're getting kind of towards the end of today's conversation. I can see that there's maybe a few more questions that I can try to get through before I leave here. Just to let you guys know, let me just double check with my team. This is recorded, right? And okay, so this is a recorded stream. So if you guys want to share parts of it, and I think probably the most helpful thing that I probably have been able to share is like when I was pointing out on the screen, on the forms, the consular notification part, please feel free to share it with your colleagues, your friends who are probably asking these same questions. Some accounts on X are sharing your live stream, spreading negative stuff about this live stream. I don't really know what negative stuff that they're putting up on about our live stream, but I think I'm trying my best to answer as many questions as possible. So if they have something to say to me, then say it to my face. Because I'll tell you one thing, right? Which is that I take a lot of pride and I take a lot of thought when it comes to my role as an attorney on behalf of this firm. I take very seriously my role in being the principal immigration attorney, but I'm not perfect. I'm more than happy to answer as many questions. And I'm also the first person to say like, hey, like I would love to get an update. I would like to be proven wrong because I'm not inhuman. I'm not inhuman. But what I will tell you is that the 100K fee exemptions are very, very clear. The H-1B guidelines, if you go onto the USCIS website on H-1B, if you look at the page, and I'm actually going to share it on the stream because I think it has been very helpful for people to see what us, the attorneys, look at to kind of look at these definitions. Let's see here. Right, I'm going to present because I think if you guys see what I look at, when it comes to share screen and then going into here. Right, so you guys can see on my screen. This is the section that everybody needs to be reading at this moment. The presidential proclamation on the restriction on entry of certain non-immigrant workers. So they clearly explain on who is subject right here, who is exempted, right? The proclamation does not apply to a petition filed at or after 12:01 a.m. So I'm going to zoom in here. Eastern Daylight Time on September 21st, 2025, that is requesting an amendment, change of status, or extension of stay for an alien inside the United States, where the alien is granted such amendment, change, or extension. Further, an alien beneficiary of such petition will not be considered to be subject to the payment if he or she subsequently, so after that approval, even after it was filed on September 21st and then approved, departs the United States and applies for a visa based on the approved petition and or seeks to re-enter the United States on a current H-1B visa. So, oh, did I not share it on the stage? Oh, I'm sorry, guys. I put it on the StreamYard, but let's do it. So I'm going to repeat it again. This is the most important section that people need to be focusing on. The proclamation also does not apply to a petition filed at or after September 21st, 2025, that is requesting an amendment, change of status, or extension of stay for an alien inside the United States where the alien is granted such amendment, change, or extension. Further, an alien beneficiary of such petition will not be considered to be subject to the payment even if he or she subsequently departs the United States and applies for a visa based on the approved petition abroad, right? I am telling you, it's a very limited pool of people where this applies to, right? So please go onto the USCIS website on H-1B specialty occupation. Like you literally, this page, I'll even like post it into the chat so you guys can see it right here, right? Go to this section that goes to the presidential proclamation on restriction on entry of certain non-immigrant workers. They really explain all of it right here. And if you're still not sure, don't hesitate to reach out to an immigration attorney. I'm also the first one to always say, we may not necessarily be your best fit. I really think that every single person has every right to pick the attorneys that they want to work with, but do give us a shot, right? The reality is that Manifest is a national firm. We have a lot of attorneys in our network that we can connect you with and people that we think can best help you based on your industry, skill set, and what you're looking for. So please don't hesitate to reach out if you're seeking a consultation. But yeah, to this thing. I see here negative stuff as in your law firms and Emily's ones are working against Americans. I have no idea, but if they want to say what they want to say, then go ahead, say it to my face. I am not in the position here to say whether or not we're going against Americans or not, but I think at the end of the day, my role as an attorney is to give advice when it comes to immigration law. What does immigration look like? What does it look like to become a valid worker in the United States? So I don't think I'm really doing anything about Americans per se. It's just, this is the law. This is my practice. I do immigration law. All right. So thank you, everyone. I think it's time to conclude today's conversation. But if this was really helpful, please let us know. And also don't hesitate to leave us a good Google review if possible. If you leave us a great Google review about the live stream, that would be really helpful for us. Manifest is really trying to change what immigration legal practice looks like in the 21st century. We're trying to give people more access to information as quickly as possible. We never hesitate from providing these free webinars or these free sessions where we talk to as many people as possible. We all know that at the end of the day, we're all going through these crazy and tumultuous journeys. And the least that I really try to do, and one of the tenets when it came to me being a part of Manifest, is to share that insight and that knowledge. I am not here as an attorney to be a glorified form filler. I'm also not necessarily here to cut a check. Listen, there's a lot of people in the world who can cut checks to get us to do all the legal work. I really believe that the best kind of firms are your thought partners. So even if I'm sitting here and I have to continuously answer as many questions as possible, if it makes you feel better, I just know that ultimately maybe you will end up working with me, or you're just going to have a bit of a better day. All right, guys. Thanks so much. Google reviews really help us go so far. Leave us a comment, and yeah,